Am I audible? Okay, now my topic is, it is not a formal, it is informal topic. Utility of a jurisprudence. Utility of a jurisprudence.
Sir, it's not audible.
It's not audible.
So mic it's not audible.
Hello? Yeah. This is the value. Hello? Okay, sure. Jurisprudence is, it has got highly utility. These subject can be appreciated by only those lawyers who practice at the High Court or a Supreme Court. If you ask these questions to the lawyers who are practicing at the District Court, they bluntly answer that jurisprudence is a waste of our time. They bluntly answer. And they have their own reasons also. I'm not denying that they are wrong. I'm not saying that they are wrong. They are right in a one way. Why I'm saying that? Because in a lower court, always we discuss about the facts. Question of a facts. Question of a law never discussed in the district court. Question of a law is always discussed in the High Court or a Supreme Court. So where the question of a law is involved, the jurisprudence gets it. And you are aware jurisprudence is a Latin word, you might have heard it. Jurisprudence is bigger than a law, keep in mind. Jurisprudence is bigger than law. So the law is one part of a jurisprudence. Because in jurisprudence we study so many other things. So what we study in jurisprudence, we study in school of law. Okay? We study why we make a law, purpose of a law. And obviously the purpose of a law is to be the justice. Okay? And there are multiple definitions for justice. Okay? For example, you might have heard about the Kant. Kant has his own definition of justice. Okay? Then you might have heard Aristotle. He has his own definition of justice. Then you might have heard the John Stuart Mill. He has his own definition of justice. Bentham, he has got his own definition of justice. So if you know the justice of the various authors, then that would definitely help in your case. Then we study the source of a law. Formal source of a law of three. One comes either legislation, another custom, and a third one is the precedent. Are there any other source than this? Okay. So definitely, if you look into the definition of a law, given under Article 30, okay, where the law is defined under the Constitution. Article 30, okay, subclause 2 or subclause 1? Subclause 2. So it defines what's the law. Okay, so when you look into the definition of a law defined as a subject, then those definition of a law is based upon which school of a law? Which school of a law? Or is it a combination of all the schools? Okay, so why the definition of a law has been defined under 30 in a very, very wider sense? Why it has been defined in a very wider sense to include everything? It has included the positive law, it has included natural law, it has included customary law. So have you thought why it was defined in a very wide distance? Why it did not follow one school of a law? What the point? So here comes the application of a jurisprudence. And jurisprudence is one more thing I'm telling you, it is interaction between the law and the facts. Jurisprudence is nothing but interaction between the law and the facts. Okay. So law always justifies the fact, or sometimes fact justifies the law. So that interaction you must understand, you must appreciate it. I'll give simple another example. You are aware eligibility, the dispute is going on in the Supreme Court. They are claiming so many other civil rights. Okay. So far they have been recognized as the persons. Okay. So when legislation always talks about rights, and always that rights are given to a person. Okay. So rights are always given to person. So laws give the rights, and you should know what is the right. And the right is not defined in any other statute. To understand the right, you should refer back to a jurisprudence. What is the point? So every law talks about right. Every law talks about right. Every law talks about the duty. Every law talks about the obligations. And if you know what is the meaning of obligation, what is the meaning of a duty, what is the meaning of right, then you ought to refer often table, you ought to refer the jurisprudence. And if you do not have the knowledge of jurisprudence, then you cannot appreciate between Article 19, Article 21, Article 24 and 14. Okay. So there is a lot of difference between the nature of a right conferred under Article 14, the nature of a right conferred under Article 19, the nature of a right conferred under Article 21, and the nature of a right conferred under Article 28. So the difference between those rights, if you are unable to appreciate it, then how can you argue the legislation whether it is contrary to Article 14 or not? What is the nature of Article 14? You have to read from the off-field table. Off-field table, and you are all aware. He has classified right into various class, and it has got a correlative things. Okay, so there the skill lies, your intelligence lies. So in every case, the jurisprudence gets in. For example, Article 14 talks about what? Equality given to whom? It is given to person. Got the point? So from Article 14, who is a person? Then what is Article 15? No person shall be discriminated on the ground of a caste. So now the question is that for 14, who is a person? For 15, who is a person? Who is person for 14? Because eligibility, they are claiming a person under what? They are claiming a person under 14 as well as a 15. Okay, they are claiming a person even for a 16. And you are aware, person means there are two classes of person. One is an actual person, one is an artificial person. So he is artificial person is a person for Article 14.
Not yet. Yes, sir.
Definitely, artificial is a person under 14. So definitely, if the law discriminates against any company, they can go to the court. Definitely. But what about the 15? Have you thought about it? For 15, whether company is a person or not a person. Or for 15 is the only natural person is a person. Is there anything written there? It simply says a person. 14 also says a person. So now how you can come to different conclusions? For 14, both are person. For 15, is the only natural person is a person. So why not a company? Why not a company? So law cannot be discriminated on what ground? Caste. So caste, who will have? Natural. Color, who will have? Natural. Sex, who will have? Natural. This is the logic. This is a reason. This is a logic, this is a reason. So the context of 15 is quite different. So by considering the person in the context of a 15. So the word they talks about the caste, the word talks about the place of birth, the word they talks about the sex, religion, caste. So these can be attributed to only natural person. It cannot be attributed to company. It means that for 15, only natural person is a person. So this is how you read each article in the constitution. If you cannot read the articles of the constitution in this way, then your knowledge doesn't make any sense. Doesn't it? And this doesn't help you in arguing the case. If you have the knowledge of these things, and these things where you acquire, these things you acquire only through common sense. These things acquire only through reading some materials. Okay, these are things you acquire only from a logical or a reasoning capacity. So what I say is that develop the reasoning capacity. Develop the reasoning capacity. If you do not develop the reasoning capacity, then there is no use of a jurisprudence. So just I said, and take example one more. Just in the morning I was discussing in class. Person includes artificial persons. What the point? Person includes an artificial person. And you are all aware who are the legal entity, class of a legal entity.
Companies.
Companies, one. Then who else?
Institutions.
Institutions.
Cooperative society.
Cooperative society.
God. Trade union.
State.
God.
God.
Trade union.
God.
God.
Trust.
So God is a legal entity.
Yes.
Yeah. As far as Hindu philosophy is concerned, God is a legal entity. So now, take example. Suppose when you go to the temple, something inside the temple, deity or something sculpture of a God is there. So is he legal person?
Yes.
Is juristic legal person? Is he legal person?
Yes.
Obviously legal person. Now my question is that take example if some dacoity or some thieves or robbers enters the temple inside and takes of the sculpture, just take away the statue of a Shiva or something Vishnu Narsimha. What complaint you the usually the trust committee law know this?
Stolen. Theft.
What should be the proper complaint?
Robbery. Robbery.
He is a legal entity.
Yes.
He is a person. If you take away person against his consent, then it is called a kidnap. So the question is that kidnapping, kidnap you only kidnap natural or in artificial person? Artificial person is impossible to kidnap. Keep in mind one thing: company invisible. Companies are invisible. As per the statute inside is temple is concerned, visible or invisible? So God is visible or invisible? God is a visible. So he is a legal entity. Okay. So now if you take away that person, is it not a kidnapping or a theft? Theft, not a kidnapping. So you mean that God is a property? Theft applies only for a property. Theft applies for a property because so far human body is never considered as a property. What is the point? Human body is not considered as a property. So if you take away human body, either it is a kidnapping or abduction, it cannot be called as a theft. Okay. So obviously, this is what discussion, nothing else. Logical discussion. Okay. So my question is that why can't you file a theft? I mean kidnapping against that entity of a God?
How will prove the consent of God?
So as long as that statue or Narsimha or Shiva inside the temple is a entity, the moment he comes out of it, property. So why this discrimination? So God is everywhere. God is eternal. God is eternal. He is everywhere. So it is impossible to take away.
So for the God, we are the one who affects the right. We can't come and we are the one who on behalf of themselves.
So this is what makes you to think. This is what makes you think. Whether you think sometimes may be proper or sometimes improper. But sometimes some people may reject your thinking or reasoning capacity because it is illogical. Okay. The example I quoted you, Putta Swami got a case. What is that privacy? It was said by Subba Rao in 1964 itself. Subba Rao said that Article 21 includes a privacy in a currency case in 1964. He was on the minority side. He was on the minority side, and his logic, his reasoning becomes ultimate ratio in 2017, and that was uploaded and approved by 9 judges unanimously. Unanimously. So the reaction, interaction between the law and the fact always it happens. Sometimes the theories are built, sometimes theories are reformed, theories are changed, sometimes theories are given up, new theories are connected. So this is what the jurisprudence. So you must have the knowledge. What is a person? Who is a person? Okay, what is the nature of a person? And now another thing is, yesterday I was discussing. So why this artificial person is created? What is the logic behind this? What is the reason behind this? Why it was personality is not confined to only natural back? Why it is extended, went on extending? Initially it was a company, then it was extended to other companies, then it is extended to cooperative society, okay, then it is extended to trade union, okay, then it is extended to God also, okay, then it is extended to even again that to Sophia, it is again extended to Sophia also, artificial intelligence here, okay. So why the law is went on, going on, extending to other things? What is the reason behind this? What is the purpose behind this? Have you thought about it? Why the personality concept is going day by extending to other things? Why the law is personifying so many things? It has a personified company, it has a personified cooperative society, it has a personified institutions, it has a personified God, okay, it has personified even the artificial intelligence here. Why it is a personifying? What is the reason behind that?
For the benefit of the society.
Because by personifying something, the society gets a benefit.
Yes. And there is an ease of administration.
It is easy for administration, and the activity of a society would be multiplied. Suppose, take example, had it been the company is not there, what would have happened? No trade, no commerce conveniently can carry it. So you face so many problems. So the law creates a personality. If it is a society is likely to benefit, likely to get the benefit advantages. It then the society will personify that thing. So by personifying the God, society has got a benefit.
Yes. Yes.
I'm telling you, if the God is eatable God, no one would have personified the God. Okay, so they are aware the God is non-eatable. So they are aware that the God is doesn't eat something, doesn't use all his property by himself. Ultimately, the property of a God is belongs to community, society. So that's why he is a personified. Now this is the reason. This is the logic. Now recently, I'm telling you, Uttarakhand High Court, and there is something just I'm thinking of that. In Uttarakhand High Court, this is that Ganga River is a person. The Supreme Court quashed it, that is a different thing. But the High Court said that Ganga is a person. Let us personify river.
Yes.
Personify river. Good idea or bad idea?
Very good idea.
Personifying God is the one thing, personifying company is the one thing. Personifying river is the another thing. What is the difference between a company and a river?
You can sue the
Company is invisible. River is visible. What is the point? So whether the company has its own actions or no actions, it has no actions. What is the point? River has it has own its course. It has got its own actions and reactions. Now the question is that can you personify a river? What is the advantage of it? What is the benefit of it? If you personify the river, okay, the one you know characteristic of a person. Once you are in person, then you can sue others who are violating your rights. Okay, and others can sue you also if you are violating their rights. Is one of the important characteristic of a person. So if you personify the river as a person, so it means that you can sue river, and river can sue you. Possible, right? Huh? There will be some. And one more thing, how the artificial person activities are carried through middleman, no? Through middleman, through natural person. So obviously, if you personify river, there has to be some human agency involved in protecting the river. Okay, so that human agency, either trustee or either chairman or something else, they may take action against any person who is polluting that river. Possible. So you can maintain the purity of water in a more effective manner because government is billed to maintain the purity or pollution, checking the pollution. So if you create a personality to the river, so river can check the pollution in a most effective manner. Possible? Possible. Is it beneficial to the society?
Yes.
Advantageous to society. So better way to personify rivers. There is one more disadvantage also. What is the disadvantage if you personify the river?
In case of flood,
If the rain happens, if the flood happens, if the cyclone happens, if the road, the Yamuna eats entire North India, okay, then what will happen? Then everyone will sue the river. And if everyone sues the river, what is the consequences? And is it workable? Is it workable? Or if you want to say that yes, the river can be a person, only it has a right to sue, but no one can sue against the river. Can you come with that solution? Or take example, even in New Zealand has given a personifications to one of the river. In New Zealand, even in Bolivia it has happened. Even Amazon river has been happened. Okay, take example, even the Western Ghat. Western Ghat, the World Heritage has recognized one of the most important thing for the survival of a human being in India. Okay, if Western Ghat is given a personified, what will happen? So these are the things where these are the things that have any practical application or no practical application. Yeah, it has got most practical applications. Got a point. So where this is a jurisprudence lies here somewhere. Jurisprudence is very abstract, very abstract. Doesn't have a definite subject matter. Again, I'm telling you, it doesn't have a subject matter. It is whatever you connect law with the facts that all talks about the jurisprudence. Another example I'm telling you how useful the jurisprudence is. Article 368 of the Constitution, you are aware. What is Article 368 of the Constitution? It provides the procedure of amendment. Now it is a power and a procedure. Earlier, when it is originally enacted, it was merely power to amend the Constitution. What is the point? And you are aware, Sajjan Singh and the Century Prasad case. Okay. So there they said that again it was in Century Prasad case it was a 5 versus 0, and in Sajjan case it was a 5-3-2. Then when it came to Golaknath case, again it is a 6-5. In Keshavananda Bharati, it is a 7-6. That was the ratio. What was argued in the Keshavananda Bharati case is a very old jurisprudence. Keshavananda Bharati case is entire jurisprudence. Okay, even Menka, every case is jurisprudence. I'm not saying that it's not. And the entire case are jurisprudence. In the Keshavananda Bharati case, the most important thing, the parliament came, the government came before the Supreme Court. You are aware of the facts of the Keshavananda Bharati case. Okay, he questioned the Keshavananda Bharati is the head of some matter in Kasaragod district of North Kerala. He questioned the power of the parliament to amend the constitution because it merely provides a procedure to amend the constitution. So he says that, and you are aware school of a law. You are aware school of a law. Positive school you are aware, natural school you are aware. So what the Indira Gandhi government, the Solicitor General argued that Article 368 gives a power to amend the parliament. Okay, there is no limitations. Limitations have been not mentioned. Okay, so then it simply says that follow this procedure, I can do anything. This is what he said. So here, the Solicitor General of India simply relying on the Austin theory. Okay, he simply did because article provides me to amend it, I amend it. The only condition on me to follow certain procedure. If I comply that procedure, matter ends, I can do anything with the constitution. So almost all he is relying on the Austin theory. Nothing wrong with it. What he is saying, Absolutely right. It is not illogical. It is not irrational. But counter to this, Palkiwala, okay, who is representing the Keshavananda Bharati, Swamiji, he said no. That 368, there is a limitation, and that limitation is inherent there. Even though it is not mentioned, you have to read that limitations. You have to read that limitations. You have to find out that limitation. Limitation is there. It did not be written at all. It did not be mentioned at all. So that is what the common sense is said. What the limitations there? It merely talks about the procedure, but yet that procedure has substantial limitations. It has substantial limitations. Okay. So now I'm telling you, we have built the constitution. Okay. And we have built the constitution after 2 years, 9 months consultations. What is the point? And with a unanimous. And our constitution is a product of a reason. Our constitution is a product of a reason. It is a product by reason, not by man. Keep in mind. So every article is debated, every article is discussed, merits the pros and the cons. Then we have selected these articles because of these reasons. Okay. So what Nani Palkar argued, we struggled against the British. We struggled against the British. We fought against the British for 2 years. So many lives are sacrificed. Why? For what purpose we struggled against the British? To have a democracy, to have a liberty, to have a freedom, to have our own legal system. So after so much struggle, after sacrificing so many lives, we have this constitution, and this constitution talks about the democracy, it talks about the parliament, it talks about the election, it talks about the judiciary, it talks about the limited government, it talks about the human rights, it talks about the election, it talks about the franchise, universal franchise, it talks about the equality, it talks so many things. Okay. So when we have built the constitution on these parameters, what are the important parameters of our constitution? Democracy. Our constitution is built on the principle of a democracy. Our constitution is built on the premises of a human rights. Our constitution is built on the premise of a limited government. Okay. Our constitution is built upon the important thing, the independent judiciary. Our constitution is built upon the important concept of a judicial review. Okay. Our constitution is built upon the important aspect of a multi-party system. Okay. So these are the very basic. And he argued that if by Article 368, if you drop these things, if you take away these things, if the absolute government in the parliamentarian, if it makes that one party system or one family can lead the government of India, is it a permissible? Indira Gandhi had absolute majority in the upper house and the lower house. Yes, I had all the majority, all the numbers. I comply the procedure and I make one amendment that it is only the one family will rule the India. And I make that India is not republic, it is a monarchy. I make a hereditary. Then the family is always the head of the India, and it is supported and passed, and the president puts a signature. So whether 368 complied, complied. Allowable? Allowable? Why? Why you are not saying that not allowable? So because Article 368 doesn't really contain any explicit prohibition. Another thing is that what the solicitor argued, constitution makers aware that our constitution needs to be amended. That's why 368 provided. But next thing is that when they provided the 368 amendment to the constitution, don't you think they should have put some explicit limitation? They should have put or not put? Should have put it, but they have not put it. It means they have given absolute power to the parliament to amend any article of the constitution. Is this logic right or wrong? My logic is rational or irrational? My logic is rational or irrational? Rational. Fine. Okay. My logic is rational. What the solicitor arguing, nothing wrong with that argument. So what the Palkiwala is coming, no doubt. There is no explicit prohibition. Okay. But everything need to be written. Everything need to be written. He says some things need not to be written. Something is to be understood. Something is to be understood. So with that situation, the constitution makers have not thought about mentioning it. Because the legislature would understand that these are the basic things they would not take away, and they thought that the legislature are sensible people. They thought that legislature would be a responsible person. They would not never thought that the kind of a legislature we have then they would have mentioned everything in the constitution. What the point? So Nani Palke argued that no. They are not mentioned doesn't mean that there is no limitation. There are limitations, common sense limitations. Okay. So what Nani Palke argued, state is created by whom? Constitution. So constitution is what? Master. State is what? Servant. What the point? And who is given power to the state? Servant. Master has given power to the state. And what the state is saying? What the state is saying? I have exercised my power given by you. I will replace you. I will bring a new constitution. Are you getting? Okay. Can a servant says to his own master? Huh? Can a servant says to his own master, you are no more my master? Huh? You are no more my master. I will have another master. If the servant says like this, what would be your reaction? Permissible or impermissible? Impermissible. So what the Nani Palke was saying? Rational or irrational? Rational. Both are rational. Both are right in their own way. Now the question, what is the choice between the judge? What is the choice between the judge? Neither attorney is wrong, nor Palkewala is wrong. Both are right. The jurisprudence will talk about which one is the most appropriate right. Which one is the most appropriate? And now how do you determine which is the most appropriate among the reasons? And now again I'm telling you, every fact will have multiple reasons. Every fact will have multiple reasons. Every truth will have a. Do you think that one truth will have one reason or multiple reasons? Truth will always have a multiple reason. So which is a reason justifies that truth? Now find out. Choose it. Judge has to choose it. So among these two reasons, what Nani Palke was the most appropriate, or what the Solicitor General of India was the most appropriate? At that point of time, it was the Nani Palkewala argument, rationality looks to be more appropriate than others. Okay, what the jurisprudence tries to tell you, it tries to give you some kind of insight, some kind of a light knowledge in which way you go, it is a better. It may not provide you perfect solution. Okay, because the plaintiff also comes with own justification and the defendant also comes with their own justification. Both are right in their own way. So the only thing is that you should select the which one is the more appropriate after taking into pros and cons. So jurisprudence, it is nothing but testing your theory in reality, testing your doctrines in reality, testing your principle in reality, testing in your rationality in reality. So that's what the jurisprudence does. So if you have knowledge about these things, then obviously it will make you good lawyers. Take an example of LGBT now, it's going on. They are fighting for their own rights. They are fighting that we must have all the civil rights which the others, our counterparts, are enjoying. And some persons are opposing it. They should not be given this right. They are recognized as a human being, it's enough. They should not be allowed to go beyond that. And they are saying that why you should not be go beyond that. Whatever rights you have, the same rights you should have. So why you are making discrimination? Because Article 14 prohibits the discrimination, 15 prohibits the discrimination. Why you are discriminating us? So whatever way you are born, the same way we are also born. So we are also product of a nature. You are also product of a nature. So why you are imposing your views on us? You are heterosexual people. We are homosexual people. So what's wrong with the homosexual people? What is the right with the heterosexual people? And you are saying you are right because you are in more number, and they are wrong because they are in a less number. So it is all about the rationality, reason. It's all about numbers. Rationality, reason is all about numbers, or it is all about a purely rationality. It's a purely rationality. When it's a purely rationality, that's why the Supreme Court of India always talks about the constitutional morality. So constitutional morality is a purely rational. It does not depend upon the numbers. Even if you are alone, even if you are a dissenting person, you are entitled to get the protection of a constitutionality. That is what the Supreme Court has founded in the Nash Foundation case or LGBT case. Okay, National Legal Service Authority case. Now it is the next stage. So it is the extension of the National Legal Service Authority case. Now, should they be? A lot of people saying that it should not be. Otherwise, they will corrupt the society. They will corrupt the society, or the structure of the society will be changed. This is what the counterpart is alleging. So they are saying that what we are going to corrupt the society. Moreover, it is going to be allowed only within the mutual consent. It is allowed only among the adult persons, and it doesn't harm others. Is the activity of a homosexuality among themselves with a free consent among the adult persons, does it harm the neighbors? Does it harm neighbors? It doesn't harm neighbors. If it doesn't harm neighbors, what is the role of a law in that matter? It purely comes within the privacy. If my actions are harmful to you, then you can prohibit it, ban it. And that's what the John Stuart's liberty concept. Whatever is non-harmable to other person, I should be allowed to do that. That is the limit of the liberty. So liberty can be curbed only if my actions are harmful or incompatible with the others. So in this case, my action with my colleague, with the consent, free consent between the adult person, nothing to harm to the society, I should be allowed. Now, the next questions they are arguing, what is their argument is that even if it is allowed, okay, you can have it. Already it is allowed now. Already it is allowed. They are saying that it is allowed because you are not officially recognized my right to choose my partner. Officially you are not recognizing it. Unofficially you are allowing it. Okay, I should be entitled to choose my partner officially by registering as a spouse. What is your problem? This is a question. They are saying that the concept of a marriage is different. The concept of marriage is different. Concept of marriage is a continuation of a generation, procreation of a human beings. That is the test of a marriage, and that is not in your case. So that is we are not allowed. This is the logic they put it. Then the counter logic they put it. How many of a couples have children? Counter logic is that how many of a couples are having a children? Then why you are recognizing them as a couples? Huh? Why you recognizing? They should not have been recognized as couples. So if they are similar to you, if they come your own class, you do everything for them. What the point? Then what you did for them? You gave adoption. What the point? And then what? Not only stopped here. What you did? Surrogation. The surrogation you allowed. So when heterosexual people question comes, you do everything for your convenience. So then why don't you do the same thing in respect of heterosexual people? Because just you do not like them. Understood? LGBT case is a purely jurisprudence. We don't have any history, we don't have any decided cases, we don't have anything. Only thing we are guided by the Western precedent cases. Okay, and now I'm telling you, if you do not have the knowledge of all these situation information, then what you argue about the Article 2114? What you argue? In argument, you speak about 90%, you speak about the facts only. 10% you speak about only provision. What is the point? In the argument, whole day you argue. Take example, I am telling you Nani Palke wala. Okay, that Keshavananda Bharti case ran for nearly 73 days. 73 days it was discussed. And at that point of a time, the maximum strength of the Supreme Court was a 15. At that time, maximum strength of the Supreme Court was a 15. And how many judges heard this? 13. So it means that entire Supreme Court heard the Keshavananda Bharti case. Entire Supreme Court. Nowadays, it is a case is heard by benches. It's now unthinkable. The 13 judges. Okay. So now 73, and only the Nani Palke argued about Article 368, 13. Keeping only two articles, 245 to some extent. 245, 368, Article 13, preamble, something. I tell you, he argued uninterrupted, continuously, 32 days.
from 10:30 to 5:30. From 10:30 to 5:30, continuously uninterrupted total argument. Nani Palkiwala made 36 days. So there was a break. 32 days uninterrupted. He had to do what he had to. 10:30 to 5:30. How many times he might have used the word of Article 13, Article 368, and the preamble of the Constitution, and Article 245, 246, and 47? How many times he might have said? You take even 1,000 times. Okay. Does it require 32 days? No. Then he must have said only about the facts, only about the information, only about the data. And if you are, brain is a good in a collecting information, data, knowledge, then only you can connect with the law, then only you can argue very efficiently. And again, I'm telling you, one of the famous jurists, Julius Stone. Julius Stone says that no person becomes a lawyer just by learning the law. Is a definition of our jurisprudence. No person becomes a lawyer just by learning the law. What it means. Bar Council of India is there. University is there. College is there. Qualified teachers are there. Okay, they have prescribed the syllabus. We taught you for 6 months and you attended the classes and you wrote the exam 3 hours and got the rank 90%, 95%, and still that fellow doesn't recognize you as a lawyer. What it means, what you should study.
Jurisprudence.
What you should study. Russia. क्या पढ़ने का फिर? Constitution में 395 articles you read very well. Verbatically you know everything. But still that fellow doesn't identify you as a lawyer. It doesn't mean that you are identified as a lawyer as a technically. Technically, you are identified. Yes, you bar, you got passed, you enrolled in the bar. Yes, you are a lawyer. But he says that you are not a true lawyer. He says that you are not a true lawyer. You are not a successful lawyer. So you could be called a sundry lawyer, but not a true lawyer, successful lawyer. And who is called a true lawyer and successful lawyer? You read any case related to very, very, very fundamental issue like a liberty, life, okay, basic things. Then it's all about the philosophy. It's all about philosophy. For example, the Keshavanda Bharti case runs about nearly 800 pages. Okay, already I told you a lot of times, even writing a judgment, such a lengthy judgment is unwanted, uncalled. Okay, and I don't know why this we write such a 800 pages judgment. Okay, and the judgment is meant for common man. Judgment is meant for a common man or it is meant for intellectual people? Common man. And you should understand the capacity of a common man. And even if the same judges are asked to read it, they don't read. Those judges who have written the judgment, if they ask him to read it and tell him to reproduce it, definitely they commit a mistake. They commit a mistake. So that is why this is also jurisprudence. The best way thing, I'm again telling you in the class, the best way thing to escape from the criticism, write a lengthy judgments. They don't read it, they don't criticize. If you write it very short judgments, then obviously everyone reads it, everyone criticizes. So why should I invite my trouble? So again, I told you the same thing happens in the case. Okay, the case is a judgment about 1050 pages. So better to keep it in a windows. Better to keep it in a showcase. So see, our Supreme Court writes such a lengthy judgment. And if you read it to House of a Lord judgment, if you go and read the House of a Lord judgment, now it's the Supreme Court now. Okay, hardly they write a judgment more than 10 pages. More than 10 pages. So immediately you can read it, immediately you can understand it. So this is why a lot of times I used to ask a question whenever I get the opportunity to judges, why you write a lengthy judgment? He answers me, no, why I write a lengthy judgment? Because the lawyers argue very lengthy. Let them argue lengthily, but you have ability to write it precisely. No. And another thing is, this is the mentality as they inherited from the days of examination. And we are also here. You are also aware here also. Your seniors told every student must write 7 or 8 pages. Seniors, that mindset has come. Okay, so this is what is the utility of a jurisprudence. Okay. The example initially I gave one example also, dead body. It happens in the most common ways. Dead body, having some ornaments on the dead body and lying on the road or lying in the remote area. Okay. And no one is coming forward to claim it. And if you take something away from the dead body, some ornament, some gold, what it amounts to? Does it amount to theft?
No, sir.
And theft means taking a movable property. Okay. So gold is definitely movable property. And next thing is that it must be in the possession of a someone. And without the consent of that person. So the question is that whether that dead body is in the possession of a someone or it is not in the possession of someone. I am giving you example where the dead body is lying in the remote forest. Suppose the example, if the dead body is lying on the road, immediately accident happened. If you take it, or in case of a railway accident, railway accident happens, and most inhuman act on the part of our human being is that go to there and they try to take away purse or some modern things from the dead bodies. What happens? They commit it.
Theft.
And you are studying what is the possession? The property must be in the possession of a someone. Okay, possession means you must have consensus. Then only you have possession. If you do not have consensus, you cannot have a possession. So dead body has having consensus or no, conciseness, no consent. So it is incapable of having a possession. So taking away ornament from the dead body doesn't amount to theft. So whether that logic right or wrong?
It is still a theft because legal hire can claim.
The legal heirs doesn't aware.
Yes. It's predominantly in the mind of the authority that the legal heirs know the about the ornament or that possession. They know that thing. They're aware of the fact.
So it is a right to hold that even though dead body, even though the relatives are unaware he is a dead, okay, and till you say that the dead body is in the possession of their heirs. Should it be? We should come to that conclusion. Even though heirs of the dead body unaware that he is a dead. What the point? Unaware.
Nothing is
Okay. So in that situation also, still that person is having the possession of the dead body without the knowledge also. That should be the right approach. And if we have this approach, whether it would promote justice or injustice, it would curb the mischievous things. If we have this concept that dead person is in the possession of their heirs, dead person, because dead person is not property, is in the possession of their heirs without their knowledge. Now the thing is that whether you have possession with knowledge or without knowledge.
It is an exception, sir.
To have possession knowledge is required. I think all of you are having a purse. You are having a purse? You are having a purse. How much notes inside the purse? How many coins inside the purse? Tell me precisely.
I do have.
How many 5 notes? How many 20 notes? How many 100 notes? No knowledge. No knowledge. It means that you are in the possession. So knowledge is required or not required? Not required. And next thing is that how many articles are there in your house? How many articles are there in your house? How many spoons? How many plates? No idea?
It is not required.
No idea. But you have the possession.
The basic idea you have that.
So possession exists without the knowledge. And now the thing, take example. If I insist that if you want to have possession of your spoon, you must have the knowledge how many spoons are there. If I insist it, then what happens if I take one spoon? Then I will not be held liable for theft. Got the point? If I say that you have all the possession inside your house without your knowledge, if I take away something from your house, then I will be held liable for a theft. Okay. So same logic can be applied to dead person. Yes. This is what is the connectivity. This is the pros and the consequences. So what is a good or what is a bad? Evaluate it. One against another reason. Then you come to conclusion. Yes, this could be. And one more thing I'm telling you. You might have participated in one or other moods. Okay, when they give you problems. Okay, so when you understand the problems, you read the problems. Okay, and then you try to find out which are the provisions are applicable to these problems. Okay, now you try to interpret that provision in the light of the facts. Okay, now you interpret that provision of the law in a such a way which favors you. What is the point? Okay, and that's what the jurisprudence. You try to interpret the law, you try to bend the law, you try to mold the law, okay, with some justification of facts in your own favor, and that is ultimately done by the jurisprudence. That is not done by the constitution. That is not done by the contract. Okay, and the law is always uncertain, will be uncertain, bound to be uncertain. If the law is certain, then the jurisprudence would not have required. You got the point? If the law is certain, we would not have required the assistance of a jurisprudence. So why we need the assistance of jurisprudence? Because the law is always ambiguity, law is always abstract, law is always speculative. And I'm asking you one question. We have a constitution built after 2 years of discussion, 9 months of discussion. After experiencing 70 years, do you think the constitution is now well settled principles?
Still balanced.
Why we again Chandrachud required? Even after 70 years. So law is, constitution is not a settled. Constitution is always dynamic. Always used to know a lot of the time law is organic. Okay, law is a living law. What do you mean by living law? What is an organic law? Law doesn't grow on its own like a man and trees. Okay, law grows with the growth of facts. Law always keeps a change with the pace of the change happens in the society. So the role of a lawyer is connect between them, interpret the law. That's what the role of a jurisprudence does. And if you do not have the skill of this, connecting jurisprudence with the law, then you are missing the most important aspect of your professions. And this is, you get it only by common sense, only by experience, only by observation, I told you. Only by reading more and more and more laws and more books and more case laws. The best thing I always tell you, you read the more case laws, you become a more perfect. And what you read, what you do, merely you read a commentary, you write. Go to original reports, read the case, even it takes more time, don't worry, it will help you a lot. Read the cases, read the reason given by the judges, read the majority judges, read the minority judges, read the concurrent judges, the reasoning, then you apply your mind whether these judges are right or wrong. Don't take them, they are right. Okay, because you are also human being, you are also having a reasoning capacity. So understand the reasoning. Then you judge whether that reason is right or wrong. And if you practice this, then definitely that will help you in your careers. And if you do not go by this approach, by this method, I think then you are studying the law in a very stereotype educations. Stereotype, nothing else. ನಿಮ್ಮ ಅಪ್ಪ ಸೇರಿಸಿದ್ರು ಬಂದ್ರಿ ನಾವು ಹೇಳಿದೀವಿ ನೀವು ಕೇಳ್ಕೊಂಡ್ರಿ ಬರದ್ರಿ ಪಾಸ್ ಆದ್ರಿ ಹೋಗ್ರಿ ವಾಟ್ ಇಸ್ ದಟ್ ನಥಿಂಗ್ ವಾಟ್ the point? So don't become a stereotype lawyers, become a vibrant lawyers. And if you want to be vibrant lawyers, then use your brain more effectively. So that's all about this.
Is anyone have the query can ask?
Yeah. Okay, you can ask your questions.
Queries?
No queries. Then all my 1 hour wasted. Huh? Then I delivered lectures to bring Gomteshwar. Huh?
Vamshi bro.
Obviously, our society is a plural society. What? Yes, heterosexual are more number, homosexuals are in a less number. And the constitution talks about the constitutional morality. It doesn't talk about the popular morality. It doesn't talk about the social morality people. There's a lot of a difference in constitutional morality and the social morality. So what you are talking about from the context of a social morality and what the judges decide about the constitutional morality, and already they have given you very sufficient by identifying them as a person in a national legal sense authority, and definitely I don't think that they will deny them, and whether you like it or do not like it, you accept. And moreover, I am telling you, the bench headed by none other than, and you know very well of his background. He is from
Yes.
Harvard University, and his father studied in a Bombay government law school. Okay, and he said one time in case of adultery, I have corrected the mistake committed by my father. He said in adultery, because the father was upheld that adultery provision was constitutional, and the son struck down it. Why is the son struck down it? Because he studied in the Harvard. He thought that liberty is more important than security, and father studied in the very traditional Bombay government law school, and he thought that security is more important than liberty. So that change of philosophy happens. So sometimes your case, fortunately, your case sometimes goes against the person philosophy is contradictory. And Chandrakshud, you are always now you might have expected what the behavior is. Justice Holmes, you know, Justice Holmes says that legal realism is what judge decides is the law. So ultimately, they will. It is just mere writing on the wall. Only time factors. It may be delayed for another 1 year or 2 years. It won't be denied. It won't be denied. बोलते हैं ना वो क्या है? What is that in English slogan? You know, अंदर अंदर है लेकिन क्या? Just what is that? There. Okay. Any other questions? Sejal, no questions. Okay.
On the behalf of Jurisprudence Club, I would like to express our gratitude to Subhash sir for the excellent lecture he delivered to our students. Once again, thank you, sir, for exceptional lecture and your commitment.
Thanks.
One more announcement. Tomorrow is there, MUN is there, so the tomorrow class is being cancelled, and the further notice will be given on the website.